We're going to be talking today about the proposed application review and processing rule subchapter and additional rules that we're not sure exactly where we're going to put them in the chapter yet. And then after that, we'll be talking about the proposed new penalties for regulatory violations. That consists of 3 different documents. One is proposed rule. The second is a proposed penalty policy that will not be actually codified in the rule, but will be adopted in the manner of a rulemaking. And third is the penalty calculation worksheet, which is a tool that agency employees will use to come up with the penalty amount for marketing and regulatory violations. And if you stick with me until the end, we will go through a few examples of how to fill that out and show you how it works with a few examples. So to get started, first of all, as you probably know, and if you've been following this process, the Sunset Commission and the legislature recommended that we make some changes to our protest process to align it with best practices to improve consistency and accountability for applicants and for the agency. It was this recommendation from the Sunset Commission was codified in changes to the code at 11.43, the addition of 11.431. There are 3 main changes that come with this. The first is that protests will now only come from external parties. There will no longer be an internal protest coming from the commission itself. Second is that external protests, these protests have to result in either a denial of the protest or referral to the State Office of Administrative Hearings. The third main change is that all of those protest hearings will be before the State Office of Administrative Hearings, and county judges will no longer be involved. We are required to adopt rules to govern this process, including provisions addressing roles and responsibilities, timelines, and informal dispute resolution. So that's what these rules are intended to address, and they must be adopted by the end of this year, by December 31st, 2020. A second recommendation along these lines was that TABC should clearly inform applicants of their due process rights. That's going to be done sort of in parallel with these rules. We're also working on some new form letters and language that will go out during the process to let people know what their rights are and how to exercise them. So those letters are something we're just getting started working on now, and will be an adjunct to this process. So we're just going to go through the rules, starting at the top, 33.51. This is a new subchapter E. And if you have any questions, or if you want me to stop on a certain rule so that you can make a comment, I'm just going to watch the group chat. So just type your question or comment in. We're starting with the usual purpose and authority, which we pretty much have at the beginning of every chapter or subchapter. And then I've tried here with the definitions to really separate out a complaint and a protest. I think in the past, those terms have sometimes been used interchangeably. And so the idea here is to make it very clear to users of these rules that a complaint is not a legal proceeding, doesn't initiate a legal proceeding, whereas a protest is you are asking to be a party to a legal proceeding. And hopefully that will make it clear to the public what they intend to file, what they want to be filing, and they'll appropriately file as either a complaint or a protest. Reasonable grounds, there have to be reasonable grounds to move forward with an allegation. So we've defined that here as things that are, it has to be within our jurisdiction. We're not going to be able to move forward if it's something that we can't have any impact on because we don't have anything in our code that allows that. And then it needs to be supported by credible evidence or information. Some reasonable grounds include these sections of the Alcoholic Beverage Code, 1146, the ones that are listed there, you can see that's not an exclusive list. That's just, we know that those things are reasonable grounds that you could cite, but there might be others as well. Rule 3353 is essentially, tells you what you have to do to file a protest. Again, this is a protest, not a complaint. So this is a person from outside the agency asking for a hearing. Person has to have legal standing. It must be timely filed. It must be in writing. And then we have narrowed down how protests should be filed. We're still maintaining a mailed option and an online or email option so that people who don't necessarily have access to the internet very easily can still handwrite a letter and drop it in the mail, and that will work. So we have a couple of different ways that people can file a protest. This will help cut down on, they can come in all different ways right now, and we're hoping that by standardizing this, we'll be sure to properly categorize communications as protests, and nothing will ever be miscategorized as a complaint or slip through the cracks or not get to us. So the protest time limits are actually very important and something that we've had a lot of discussion about. So we'd really welcome your input. A protest must be filed for an original permit or license between 60 days prior until 50 days after the commission deems the application complete. The idea here is we need to give some kind of a window, and we need to give enough time after the application is complete and shown as pending in our system to allow people to file that protest. So that's what the 15 days comes from. Generally right now, we're not granting permits within 15 days. I think the average is somewhere around 40 or 45. So that 15 days is just to allow enough time for someone to see that the application is complete and file that protest. For a renewal, they know that's coming. Everybody knows that's coming, knows what the expiration date is. So if someone wants to file a protest on a renewal, they need to do that within 60 days prior to that expiration date. A protest has to include the first and last name and physical address of the property of the home of the person protesting. This is important because we have had people file anonymous protests before, and the issue there is that without the person's name or location, we can't determine if they have legal standing to request a hearing on the matter. So there will no longer be anonymous protests. On the other hand, anonymous complaints, which do not require standing, those are still allowed. We're requiring the distance from the premises, contact information, reasonable grounds. Government official needs to tell us, their contact information, their jurisdiction, and their basis for the protest. And if a protest fails to meet any of these requirements, it'll be rejected, and we'll let you know why. And if you want to refile with a corrected protest, you can do that within the time limits. Or if someone's not going to meet the requirements, they can refile as a complaint rather than a protest. Protestant can always withdraw their protest at any time. And if there are no protests and all of the other laws and rules are complied with, the executive director can then grant the application. So that's the subchapter E on protests of license and permit applications. Here's a question. Does it affect the current rule regarding protestants must live within 300 feet in order to protest? It does not. So that's the reason for the requiring people to let us know the approximate distance of their home from the premises, as we're not changing that at this time. Now we're moving into some rules that we haven't actually decided exactly where in chapter 33 they're going to go, so that the rule numbers are not there. So I'm just going to refer to them by the titles. We have some more definitions that are pretty basic. It's important to know that we're going to consider applications received only when we have everything we need. And when we have everything we need, that's when we update that public database to show the application is pending. So that's how you know that it has been officially received, is when that pending tag goes up. Application approvals, we've delegated those to the executive director. Then we have a conditional approval rule. And the reason this came about is that we just talked a minute ago about the timelines for filing protest. There may be some circumstances when the executive director wants to issue a permit or license before that 15-day period expires. In the event that that happens, we've come up with this idea for a conditional approval. We still need people to have the ability to protest, even if the executive director wants to grant that permit before the 15 days have expired. So what we've come up with is a conditional approval. The executive director would say, okay, 15 days haven't expired, but you're conditionally approved. If a protest comes in within the 15 days, we're going to have to, we're going to go through the process for that. An applicant then can choose to proceed with whatever they're doing. If they're retrofitting a leased space, or if they need to hire employees and train employees, whatever they want to do. However, if during that 15 days a protest comes in, we go to hearing, and the permit is eventually not issued, all of the actions that they took during that conditional period are at their own risk. So, if you don't get your permit and you've spent a bunch of money on outfitting a leased space, that's at your own risk. That makes sure that people who have the right to protest have that right protected. We have a computation of time rule, and we're hoping at some point to get things like computation of time into a rule section that applies to the whole code, but that's going to be on probably the next rewrite. Applicable rules, application is subject to the rules in effect as of the date the application is received. So not the date that you send it to us, but the date that we look at it and say, yes, we've got everything, application pending, it's been received. Then we have some rules here about referral, denial of that application after referral for hearing. If we send a protest for hearing and the executive director says, I know the protestant had a problem with that, but we do too as an agency, then the executive director will have the application remanded from SOA and send it to the commission with a recommendation for denial. In the event that happens, those protestants whose protests were granted, they're still pending, so they're not losing their right to protest. Then if the commission has two options at that point. They can either deny the application based on the executive director's recommendation, or they can remand back to SOA. And if they remand back to SOA, those protestants are still there as part of that process. They still have their right to the hearing. They cannot grant it. So that way, those folks who have had valid protests and have been referred to SOA will still get their day in court. So they just have the option to either deny the application or remand. We've got some general rules here about alternative dispute resolution. That was something the legislature directed us to include. They're pretty general and don't really change anything about how we operate right now. Application withdrawn, as of course an applicant can withdraw their application at any time before it's issued. But something that's different here is that if you fail to respond to requests for additional information and repeated requests, and we can't get in touch with you for 10 days, then we can consider you to have withdrawn by that inaction. So it's incumbent upon the applicant to maintain contact, respond to inquiries, because if you don't, you may have to start over and refile. An application that's withdrawn, it has not been denied, so it can be refiled at any time. And on to the request for hearing on recommendation of denial. If the executive director recommends denial, the applicant can request a hearing with the State Office of Administrative Hearings. That's really the gist of that rule. A recommendation for denial includes a right to hearing at SOA. Now we have a rule down here regarding refunds of permit and license fees. For an original permit or license application, we'll refund the fee if the license or permit is not issued. For a renewal, it will only be refunded if the applicant withdraws or if the application is denied prior to the expiration date. The last rule we have here would codify and clarify and lay out. Oh, I'm sorry. You will have to check. So as of now, you'll have to check the TABC website to know when the 15 days begins. So it's the day that the pending is marked. The 15 days may extend the time frame for issuance. You know, like I said, right now we're somewhere like 45 days. So we were trying to choose an amount of time that would be enough time for a protestant to file, but would not necessarily extend the time for granting the application. But if you have any ideas about how to make that even more efficient, we're definitely open to that. So the final rule here is about management review. Essentially, what this does is just lay out, you know, transparently a procedure that we've been using, which is to sort of flag any premises or applicants or the applications that have an issue that needs to be resolved. And this is just explaining how that works until that issue is resolved. The application will remain pending and not be granted or denied. So that's just a quick run through of all of these draft rules. One of the things that I'd really like to ask for your input on is those few of you from outside the agency that we have here, is not only what you see here, but also if you feel that anything is missing, what is not here that you think ought to be here. That would be a really helpful input. Otherwise, if you have any more questions, let's do that right now. And if you don't have any questions right now, if you think of some later, you're always welcome to email them to me. You can email rules@tabc.texas.gov, or you can email me directly. It's shana.horton@tabc.texas.gov. Okay. There are no other questions or comments coming in on the group chat. So we will move on to our discussion of the regulatory penalties overhaul. This is something that we actually talked about in a previous stakeholder meeting where we discussed it on a conceptual level. So this is just, we're getting down to a more granular level here, looking at the actual draft documents. This comes from a sunset recommendation, again, to complete our schedule of sanctions to account for all regulatory violations, which amended the code at 11.641A. Also, to require the administrator to consider, when determining the amount of a civil penalty, whether the permittee or licensee profited from the violation, and if so, the amount of the profit. So that's completing the schedule of sanctions is one part of the charge, and then also giving us this new authority. Well, actually, it's a new requirement to consider profit when we are determining appropriate penalty amounts. Sunset report said allowing TABC to consider a business's profits from violating the law would ensure TABC can effectively penalize a licensee for illegal behavior, so that violating the code and paying a fine does not simply become a cost of doing business. So let's start here with the rule. It would be, we would just go ahead and repeal the current Rule 34.3 and replace it entirely. That's just kind of the cleanest way to do it. And then we'll be modeling 34.3 sanctions for regulatory violations off of 34.2, which are the health and safety, public safety related violations. So the rule is really quite simple. The rule just says, these are, if you act or fail to act that results in a violation of the code, you'll be assessed a base penalty as follows. And then the graphic, just like with the other violations, essentially categorizes all of these violations into one of three categories, either a $250 or $500 or $1,000 base penalty. Now, probably wondering how we came up with these categorizations. In general, the $250 category, they pertain to activities that make up the daily operations. So record keeping, displaying permits and licenses, filing reports, those sorts of things. Those sorts of things that, they fall through cracks. Sometimes people forget, they don't get done in a timely manner. We expect them to happen. Then they don't really, they pose a very minimal impact to public safety, the marketplace, and our ability to carry out our duties. So those are the $250 violations. Most of the violations fall into the middle $500 category. Those pertain to the core conduct of the permit or license's authorized privileges, often stated as a specific prohibition within the code. And then when we get to the $1,000 category, that's going to be conduct that involves, harms, or affects another person or business in some manner. So they have a heightened penalty by statute. They pose a threat to the fair and orderly marketplace, or they impair our ability to carry out our regulatory duties. So that's where that attached graphic comes from. That's another place where we'd be interested in your input. If you think that a violation has been miscategorized, we'd be interested in hearing your thoughts on that. Now, that's just the base penalty. What happens next is the penalty, the base penalty can be augmented or discounted based on the circumstances of the violation. And the way we will do that is laid out in the penalty policy, which is the next document we'll discuss. The penalty policy, like I said earlier, won't actually be codified in rule. However, its adoption will follow all of the rulemaking procedures so that it is published. We get all of the input we can get. The number of days of license or permit suspension is going to be commensurate. I'll show you how we come up with that later. And then penalty policy will always be a public document, always be publicly available. And we'll review the penalty policy and update or revise it at least once every 7 years. I would imagine that the first time around, we might be revising it sooner than that, just as we learn what works and what doesn't. So that's the rule. Does anyone have any comments or questions about the rule? Okay. Then let's move on to the penalty policy draft. As you can see, it's definitely in draft form. There's some blanks, and it's a working document. So please give us your input. This is kind of a lot to digest, but it really details how our staff members are going to think about and come up with the penalties that they're going to recommend for violations of the regulatory and marketing violations. We'll start with these first few are pretty basic rules, periodic review. Violations subject to the policy, again, it's just the ones in Rule 34.3 that we just looked at. This is not going to apply to 34.2, the health, safety, and welfare violations. That's the sunset, and the legislature directed us to work on the regulatory violations. So that's what these are going to apply to. The effect of this is a penalty calculated pursuant to the policy is what the executive director will impose or seek to impose if a settlement with the respondent isn't reached. So essentially, this isn't supposed to really change how things work right now. It's just supposed to make it more transparent. So the staff member is going to compute the penalty that they want to recommend, actually the same way they're doing it now. It's just currently in a black box, and we're opening up that black box so you can see what goes into that. And then it's an offer of settlement, essentially. This is the penalty we recommend. The parties are not bound by that. That obviously, if they agree to a settlement on different terms, they can. So it's sort of, it's the opening bid. If there's no settlement discussion, that's the penalty that we will seek to impose. Obviously, we're going to be staying within our statutory authority and penalty limitations per the code. So we'll start with the base penalties. Each violation will go, the first thing that someone will do is go to see which category it falls into under that rule that we just discussed. We'll assign a base penalty. Each category represents a single instance of a violation without considering any other factors. So that's just the base. The additional factors that weren't increasing or decreasing are not part of that base penalty. And then that base penalty, after we look at that, we'll decide how many violation events there are. This can take a lot of different forms. It can be, for example, the number of days that a violation was ongoing, or weeks or months. It could be a number of locations at which the violation occurred. There are a lot of different ways to do this, or if it's discrete, a discrete instance, you might be able to count discrete individual instances. That will be described, and when we go through the penalty calculation worksheet in a bit, you'll see how that works. It is not intended, that doesn't capture violations from last year or a different event. This is just it's intended to capture the current violation. So it's not like a compliance history thing. It's just for the current violation. Now, where we will consider compliance history and whether this is a person or a business that continually violates this section of the code, or just generally is a bad actor, that will be considered in the next step, which is aggravating and mitigating circumstances. So we've come up with a list of aggravating and mitigating circumstances. They're the ones that we consider now. Again, just making it transparent by putting the list into the out there for y'all. It's a non-exclusive list. It's in section 7 of the policy. The use of mitigating and aggravating circumstances will be entirely discretionary up to the executive director, and this is how we consider the different circumstances of different actors and of different violations. So you can even have a violation of the same section of the code or rules where the circumstances differ enough that one violation should be penalized more than another. Finally, and this is the only thing that really is a big difference. Like I said, we're really trying to just make transparent the process that we currently use, and not really change. So we're not intending to change the penalty amounts in any significant way from what you are used to. However, the exception to that is the economic benefit portion, which is the last thing we're going to consider when setting our penalty. And that's the new authority that I was talking about earlier that the legislature gave us and actually directed us to consider whether a violation has resulted in additional profit for the violator, and if so, to take that into account when assessing the penalty and make it so that it's not a business decision to just go ahead and violate the code or the rules, because that's, they'll still come out ahead. So in those cases, sometimes those profits are large, And when we add those profits to the penalty amount, that could make a very, very large number. And I'll show you an example of that when we go through a couple of examples of the penalty calculation worksheet. So that's the only instance where you might see a big difference from what you would have seen before when we were not considering the profits. The economic benefit calculation, again, it is going to be variable. It's going to be different for every case. There's a list of questions to consider. Did a respondent avoid or delay capital outlay? Did they earn any interest? Did they gain an economic advantage? And these are going to, what applies in each case is going to vary. So we can't say this is exactly how it's going to work in each case. It's just going to have to be case specific. Finally, after we come up with the total amount, we will apply a divisor that I'll show you in the penalty calculation worksheet. And using that divisor, the divisor is the base penalty amount. It will give us a number of days of suspension that a permittee can choose to accept in lieu of the fine. That's something. Suspension days in lieu of fine is something we're required to do by statute. So that's how we would do that. Then here in the policy in section 7, this is sort of an instruction sheet for people who are going to be using the worksheet, so staff members, but it also explains to folks outside the agency how they work through these steps. And you can see there in step 3, there's a pretty long list, excuse me, of mitigating and aggravating circumstances. If you can think of something that we don't have on there, please let me know. But those are non-exclusive lists. I'm not going to go through those steps. You can go through that on your own. It's similar to what I just discussed. But again, a violation or case can be settled at any time for any penalty amount or number of suspension days to which the executive director and the respondent agree, regardless of the calculation under this methodology. So again, the idea here is not to do anything radically different, just to make it a bit more transparent. And so you can see why we're recommending the penalty that we are. Does anyone have any questions or comments about the penalty policy? The question in terms of categorization, 6 offenses that currently exist in 34.2 appear in 34.3. Will they be removed from 34.2? Thank you for pointing that out. I did not personally do the categorization, and so I am not sure why it's like that. So I'm going to talk to the folks that did that and see if there's a reason that those exist in 34 because there might be different, place or manner can be a lot of different things. So there might be some types of offenses under those sections that would be more regulatory and some types that are more health and safety. But I will check on that and we'll decide what to do with those, and I'll get back to you. I haven't done this much talking in like 6 weeks, so. Okay. So let's move on to the last item on the agenda today, which is the penalty calculation worksheet. And I'm going to have Joe, it's just me and Joe here at headquarters in the commission meeting room, but I'm going to have him pull up the penalty calculation worksheet on the screen that we can all follow along with some examples. Okay. Bear with me while we get this running. All right, folks. Somebody let me know if y'all are seeing what I'm seeing here. Does everyone see my screen, the document on my screen? Anyone? Anyone? Bueller? Okay. Okay. All right, so here is the draft penalty calculation worksheet. As you'll see, it's a single page. I'm trying to keep it simple and easy to review. Each worksheet will contain only one violation. If there is an investigation that results in several violations, there will be a separate worksheet for each violation, and then the amounts of the penalties will be totaled up. So let's go through a couple of examples. We'll start with a really, really simple one. So, you know, obviously these top three lines are just to identify. This is the person that this penalty is against, and this is the complaint number and investigation number to which it applies. Violation code, that this is something that our folks use. It's a numbering system that applies to each type of offense. So that won't mean much to someone outside the agency. Description of defense of offense. Let's see, this one was failure to timely file a report. So this is a really basic one. I need to take this off of here. Okay, way prettier than this. Failure to file a report. You're going to get a citation, so you know exactly what you violated. And obviously, we talked about earlier, failure to file a report. It's, you know, it happens. Sometimes you file things late. So that's a base penalty of $250. Is everybody following along okay so far? And you can see all of this. Number of violation events. This is, you know, it's just one. It happened once. So your subtotal here is $250. Mitigating and aggravating circumstances. In this case, you know, there's really not much you can do to mitigate it. You filed it late. You can't unfile it late. So we're not going to apply anything here. There's not really anything to apply. So we're still at $250. We're just going to do none. Economic benefit, again, here, there's no economic benefit to filing late that we need to. So this one is really simple. We get down to the bottom, and our total penalty is still $250. And then the way that we are going to figure out the number of days in lieu is we're going to divide that $250 by the base penalty, which, of course, was $250. So the number of days in lieu of penalty is 1. So that's about the simplest example of a routine violation and how we would use this penalty calculation worksheet to come up with the penalty and the number of days in lieu. We'll go through some more complex ones now that you kind of have the idea of how this is going to work. Okay. Okay, so let's do another one that doesn't have economic benefit, that's a little more complicated. In this case, the retailer purchased alcoholic beverages from an out-of-state liquor store, which obviously doesn't have TABC label approval. They've been selling the product for 6 months, and when we busted them for it, they stopped selling it immediately. So we're starting up here. We've got possession of uninvoiced, unauthorized alcoholic beverage. We've got the code section, 28.06, A and B. Base penalty here this isn't one of those super egregious or public safety or anything related. It's also not routine. It's kind of a core function. So we're going with that middle category of 500. And again, how we know that is we just go to that chart in the rule. We look up ABC 28.06 A and B, and we see that it's been assigned to 500. So that's just going to the chart and looking it up. There's not any discretion there. Number of violation events. So this went on, like I said, it went on for 6 months. And in this case, we're going to use the number of months as our number of violation events. And here, you'll get an explanation of why that's a 6. Number of months ongoing. So 500 times 6, let's subtotal that here, $3,000. Next step, mitigating and aggravating circumstances. These folks immediately ceased sales of the uninvoiced product. That's what we would expect them to do, of course, right? I mean, if they didn't, that would be pretty bad. So that's ordinary, but it does mitigate. So we've got times 0.50. So that decreases their penalty because they did exactly what we would expect them to do to try to mitigate the problem. So now we're multiplying 3,000 times 0.50, and we're at 1,500. In this case, we are not going to use economic benefit, either because they didn't have a prior violation, that's a requirement for economic benefit, or just because it wouldn't have been higher than the penalty. And in some cases, we might not be able to do economic benefit because it's just too difficult to actually calculate or put a point on. So economic benefit is going to just be an NA. So down here, our total penalty, again, we're still at 1,500. And then we divide it by the base penalty. The base penalty was $500, if you remember. So the number of days in lieu is 3. Does anybody have questions about this example? And we have one more where we'll go through the economic benefit. I'm glad this is making sense to y'all. Let's start over with your last example. Here we're going to go with one that was pretty egregious and resulted in a lot of money, profits. We want to make sure that this entity doesn't do this again and doesn't make it a cost of doing business. So this is exercising that new authority that the legislature gave us to consider economic benefit. So in this one, the respondent created a retailer-specific tap handle with a logo on it, and that tap handle was distributed out to 27 retail locations throughout the state. It was also their second offense of illegal inducement within a couple of years. So that's not good. So we're up here in description of offense. We've got illegal, oh, that's ugly, inducement. Okay, that looks terrible, but you get the idea. And we've got AB code 108.06. And we also have 45.110. Our staff member goes to the rule and sees that the applicable base penalty is $1,000. It's a big one. Number of violation events, we're going to stick with one on this, and I'll tell you why later, because we're going to recoup all that money further down the way. So we're still at $1,000. And again, one way we could have gone is to say, you know, this was 27 violation events, but then that would have ended up with a much higher penalty than is appropriate. So we're having to make some decisions about best way to assess this. Mitigating and aggravating circumstances. Like I said, this is the second offense of illegal inducement. They did it at 27 locations. They should have known better. So that's an extraordinary aggravating circumstances. Second offense of same in 2 years. 27 instances. So let's subtotal that. We've 1,000. We're multiplying it by 4 for extraordinary aggravation. Our subtotal is 4,000. Now we get to the economic benefit. They did have a prior, so we're going to say they had they furnished, and it was another illegal inducement. They furnished something for an event. So we have to mark that there because that's part of the statute. It just says that you can only use the economic benefit if there's been a prior violation. So we're telling you what we're basing that on. Now they sold these tap handles, and their total profit was $27,500. So profits from sale of tap handles. Let's see, so that's our total, 27.5. We're not going to use avoided or delayed. Economic benefit exceeds step 3 subtotal. Well, 27.5 is definitely more than 4,000, so yes. If that box is checked, as you can see, we're going to add the step 3 subtotal to the economic benefit up to the statutory maximum. 32,500. And this did go on several days, so that we're not constrained by that 25,000. This essentially makes sure that not only do they not get to keep their profits, but they also have a penalty on top of that to actually penalize them. We're not just coming back to zero, we're actually also penalizing them. Again, we divide by the base penalty amount, which is 1,000, and we get 32.5. And because it's a 0.5, we're going to round up. So 33 days. So yeah, that does look different from what you might have expected before. It's much higher. The number of days in lieu is higher too. That is in direct response to what the legislature has charged us with doing, which is making these violations that have a big profit not be profitable anymore. And so that's going to make both the penalties and the number of days in lieu go up substantially. So that's the last example I wanted to show y'all. Again, this is just a tool, and it's actually a pretty flexible tool. So we can consider all the circumstances and try to make each penalty really match the circumstances of the violation. And it is a good tool to use in your settlement negotiations. So you know what we've considered and how. And so if anyone has any questions, let's get to those now. And there's math involved, so surely there are questions, right? And as far as this penalty calculation worksheet goes, this is something that if you're the respondent, you're going to receive with your notice of violation, you're going to receive a copy of this filled out. explaining to you where that number came from. So you'll be able to see this right away. Does anyone have any questions or comments about the penalty calculation worksheet? We know this is a lot to digest. So, 3 different documents here, a rule, the penalty policy, and this worksheet. And then it was a lot to digest on the application review and protest rules, a lot of rules there. So if you have thoughts, comments about those that you think of later, please don't hesitate to reach out to me. We want to get these in really good shape to where they're going to work well for all of us. And we like to do that before we go to proposal. So please do weigh in now, and thank you so much for taking the time to review these things and to give us your thoughts and comments and concerns. It looks like there are no additional questions or comments right now. So with that, I will sign off. Thank you all for being here today, and hopefully we can see each other sometime soon.